deprived of his only livelihood. Hence, in the case, Supreme Court said that is not a valid condition imposed in the grant of probation. X was charged with a crime of reckless imprudence resulting in homicide. After trial on the merits, the judge convicted him and imposed a penalty which is within the probationable penalty. The judge imposed upon him the penalty of 4 years imprisonment. Since it is within the probationable penalty, within the period for perfecting an appeal, he immediately filed an application for probation and it was granted by the MTC judge. After the grant of probation, he thereafter filed a notice of appeal. He wanted to appeal the damages, the civil indemnity imposed on him, attaching to the said conviction. The court denied to give due course to the said notice of appeal, the court saying that since your application for probation had already been granted, therefore, you loses the right to apply to appeal. You loses the right to appeal. Is the ruling of the said MTC judge correct? The judge is wrong. Even if he is already granted with probation, even if his application for probation is granted, he still has the right to appeal because his appeal, based on his notice of appeal, refers to the civil liability imposed on him. Probation has nothing to do with civil liability. The only effect of probation is to suspend the execution of the sentence. Therefore, it pertains to the penalty imposed for the crime. And civil liability is not part of the penalty. Therefore, it can never be touched by probation. Hence, X can still appeal the civil indemnity imposed on him. What if X was convicted of a crime and the penalty imposed on him was within the probationable penalty? He applied for probation, it was granted, but among the conditions attached to the said grant of probation is that during the period of probation, which in this case is 2 years, he cannot change his place of residence. So during the period of probation, he cannot change his place of residence. That is one of the conditions attached to the grant of probation. And upon the grant, he was now released. And for 2 years, he did not change his place of residence. After 2 years, however, he believed that the period of probation had already expired, had already lapsed, so he wanted to have a new life. He wanted to live in a place wherein the people do not know him. They didn't know that he previously committed a crime and he was only granted probation. He wanted to have a new life, and so he left the place and changed his place of residence. The probation officer learned about this, and the probation officer immediately filed before the court that granted the probation a motion to revoke the said probation granted to X. And the judge, upon reviewing the said motion, granted the motion and revoked the probation granted to X. X was arrested and placed behind bars. Is the judge correct? The judge is correct. Supreme Court said, the lapse of the period of probation does not ipso facto mean the termination of probation. Even if the period of probation has already lapsed, the said probationer must still comply with the conditions attaching to the grant of the said probation, unless and until an order of final discharge had been issued by the said court. After the grant of after the period of probation has already expired, has already lapsed, it is the duty of the probation officer to submit a report and recommendation to the judge. That is a report on whether the said probationer complied with the conditions attached to the grant of probation and recommendation that the case be terminated. The court, upon review of this report, will now issue an order of final discharge. This order of final discharge has the effect of restoring upon him all civil rights lost or suspended by reason of his conviction. Likewise, under the new law, it will totally extinguish his criminal liability for the said crime for which he has been granted probation. So under RA 10707, probation can now be included as among the modes for extinguishing criminal liability, because under Section 16 of PD 968 as amended by RA 10707, an order of final discharge shall totally extinguish the criminal liability of the said probationer for the said crime for which he has been granted probation. We now go to Article 89. Article 89 provides for the modes for totally extinguishing criminal liability. Under Article 89, the modes for totally extinguishing criminal liability, we have debt of the said accused. Then we have service of sentence. We have also amnesty, absolute pardon, prescription of crime, prescription of penalty, and the subsequent valid marriage between the offender and the offended party. These are the modes for totally extinguishing criminal liability. The first among this is debt. Debt extinguishes criminal liability at any stage of the proceedings, be it during trial, before conviction, or after conviction. Because the moment the accused dies, there is nobody to serve the personal penalty. Hence, debt extinguishes criminal liability at any stage of the proceedings. However, debt extinguishes civil liability only if the said accused dies before conviction by final judgment. If the accused dies after conviction by final judgment, the civil liability survives. And it can be against the executor or administrator of the estate of the said convict. The civil liability that is extinguished the moment the accused dies before conviction by final judgment is civil liability ex delicto, that is, the civil liability arising from and based solely on the crime committed. Even if the accused dies before conviction by final judgment, the civil liability survives if the said civil liability arises from other sources of obligation such as law, contracts, quasi-contracts, or quasi-debt. So, this civil liability that is extinguished if the accused dies before conviction by final judgment refers only to that arising from and based solely on the crime committed. X was charged with a crime of qualified rape. He was convicted by the trial court. The case is now on appeal before the Supreme Court. While the case was pending before the Supreme Court received a letter from the Director of Prison saying that X died while at the New Bilibid prison. And in the said letter, the medical certificate coming from the doctor was attached as to the cause of death, the time of death, and the date of the said death of X. What is the effect of such death of X on his criminal liability? His case was pending, reviewed by the Supreme Court. The death of X extinguishes both his criminal and civil liability. It extinguishes his criminal liability because death extinguishes criminal liability at any stage of the proceedings. It also extinguishes civil liability because there is yet no judgment. There is yet no judgment there is no yet conviction by final judgment. He died before conviction by final judgment because it was on appeal and the Supreme Court has not yet rendered its decision. Hence, his death extinguishes both his criminal and his civil liability. The second mode for totally extinguishing criminal liability is service of sentence. Service of sentence refers to the satisfaction of the penalty. If the penalty imposes imprisonment, it means you already served the sentence. If the penalty imposes fine, he already paid the fine. Therefore, there is already satisfaction of penalty. His criminal liability for the crime committed is already extinguished. Then we have amnesty as opposed to absolute pardon. Both amnesty and absolute pardon are acts of grace coming from the chief executive, which exempt the offender from the penalty prescribed by law for the crime that he has committed. However, they are distinguished in the following manner. First, amnesty obliterates or erases the effects of the crime as if no crime has been committed, whereas pardon only excuses the service of sentence. Second, amnesty may be granted at any stage of the proceedings, whereas pardon may be granted only after conviction by final judgment. Third distinction, amnesty is a public act of the chief executive. Hence, it is a public act of the chief executive done through a proclamation with the concurrence of Congress. Hence, courts take judicial notice of amnesty, whereas pardon is a private act of the chief executive. So courts do not take judicial notice of pardon. The person granted pardon must plead it before the court before he may be ordered release. And last distinction, amnesty may be granted to a group or community of offenders who have committed political offenses, whereas pardon may be granted to any offender for any crime committed. So those are the distinctions, amnesty versus pardon. This was asked last year, not in crime, but in political law. Then we have prescription of crime. Prescription of crime is the loss or forfeiture of the right of the state to prosecute an offender who has violated a law. The moment the crime has prescribed, the state loses the right to prosecute an offender who has violated the law. The state loses the right to file a case against him. If the accused was charged in court, and the court finds out that the crime was already prescribed, it was too late. The only jurisdiction of the court is to dismiss the case. Not to acquit, but to dismiss the case. Because there is nothing to hear. There is nothing to try. Because the crime has already prescribed. The following are the periods of prescription of crime. Crimes which are punished by death, reclusion perpetua, and reclusion temporal shall prescribe in 20 years. Crimes punished by other afflictive penalties shall prescribe in 15 years. Crimes punished by correctional penalty shall prescribe in 10 years, except those punished by arresto mayor which shall prescribe in 5 years. Libel and similar offenses shall prescribe in 1 year. Oral defamation and slander by deed shall prescribe in 6 months, and light felonies, light offenses shall prescribe in 2 months. These are the periods of prescription of crime. The crimes must be filed within this period, otherwise the court will no longer hear the case. The running of the period of prescription of crime, or the period of prescription of crime, shall commence to run from the time the crime has been committed. That is, if the time of the commission of the crime is known. But if the time of the commission of the crime is not known, the running of the period of prescription of crime shall commence to run from the time it was discovered or it has come to the knowledge of the offended party, the person in authorities, or the agents of persons in authorities. That is the time that you start counting the running of the period of prescription of crime. X and Y brothers, both drunk, had a heated argument. They fought each other by fist until one of them, X, pulled out an ice pick and repeatedly hit brother Y in the heart with the use of the said ice pick. Y died. In order to conceal the crime that he has committed, X dug the ground in their backyard and placed the body of his brother beneath the ground. Unknown to X, their neighbor, who heard the commotion between these two brothers, was peeping through an opening, a small opening on the fence. And the neighbor was a witness to everything. The fight, the stabbing with the use of the ice pick, and the act of burying. But since this neighbor was afraid of X, he kept everything to himself. He did not divulge it to anybody. But 20 years thereafter, this neighbor wanted to confess everything that he had seen. The neighbor went to the police authorities of that place and divulged that 20 years ago he saw this act of X killing his brother Y. The police conducted investigation, they went to the place and they were able to find proof that indeed X killed Y. Can the state still prosecute X for the crime of homicide for having killed his brother? The state can still prosecute X for having killed his brother. Even if the said neighbor had witnessed the commission of the crime, that is not the start of the running of the period of prescription of crime, because the said neighbor is neither the offended party nor the authorities. It is only at the time the neighbor divulged to the police authorities that the running of the period of prescription of crime commences to run. So in this case, the state can still file a case of homicide against brother X for having killed his brother Y. The crime has not yet prescribed. When is the running of the period of prescription of crime interrupted? Supreme Court said, it is settled in jurisprudence that whether it is a violation of the revised penal code or a violation of special penal laws, the running of the period of prescription of crime is interrupted from the time the case is filed before the office of the public prosecutor, even for purposes of preliminary investigation. So from the time the case was filed before the office of the public prosecution, the running of the period of prescription of crime is already interrupted, suspended, or held. So, in an argument, two neighbors, X and Y, had a heated argument. In the course thereof, X got so pissed off, she lost his patience, and she slapped the face of neighbor Y 4 times. Neighbor Y went to the doctor. Her face became reddish, and it would heal within a period of 2 days. And so she filed a case of slight physical injuries before the barangay. There was no amicable settlement. Both parties were called by the barangay, but both parties did not appear. And so, the barangay issued a certification that the said case is ripe for filing. And so, Y immediately filed a case of slight physical injuries before the office of the public prosecutor within the 2 months prescriptive period from the time of the commission of the crime. Slight physical injuries is a light felony, therefore it prescribes after 2 months. And Y was able to file it within the 2 months prescriptive period. Let's say he filed it after 1 month and 2 days. The case is now before the fiscal's office. It was resolved, finding probable cause. However, it took the fiscal's office more than a year before it was able to file the information for slight physical injuries against X before the Metropolitan Trial Court. And so upon the filing of the case, the counsel for the defense, X, immediately filed a motion to quash, ground the crime of slight physical injuries had already prescribed. The case was filed more than a year from the said act of slapping. Therefore, if you were the judge, would you grant or deny the said motion to quash? If you were the judge, you have to deny the motion to quash. The crime has not yet prescribed. The case of slight physical injuries was filed before the Office of the Public Prosecutor 1 month and 2 days from the act of slapping. Therefore, it was filed within the prescriptive period. From the time it was filed, the running of the 2 months prescriptive period is now suspended. It is now interrupted. And it remains to be suspended or interrupted until the said accused has been convicted or acquitted, or the case is terminated for no fault of his own. So when the case was filed before the Metropolitan Trial Court, the said running of the period was still interrupted and suspended. Hence, the crime has not yet prescribed. It can still be heard by the said Metropolitan Trial Court. Again, Supreme Court said whether it is a violation of special penal law or a violation of the RPC, the filing of the case before the Office of the Public Prosecutor interrupts, suspends, halts the running of the period of prescription of crime. Then we have prescription of penalty. Prescription of penalty is the loss of the right of the state to place the convict behind bars to execute the sentence imposed on him, to suffer the sentence imposed on him. The moment the penalty has already prescribed, the state loses the right to place this convict behind bars, to suffer the penalty imposed on him. The following are the periods for prescription of penalty. Penalties of death and reclusion perpetua shall prescribe in 20 years. Other afflictive penalties shall prescribe in 15 years. Correctional penalties shall prescribe in 10 years, except arresto mayor, which shall prescribe in 5 years. Life penalty shall prescribe in 1 year. These are the periods of prescription of penalties. X was charged with the crime of homicide. Having been charged with the crime of homicide, which is a bailable offense, X posted bail. And after posting bail, the moment you post bail, you sign this document. And this is a document which states that the moment you fail to appear in the court, you waive the right to hear the said case against you. And so the case can continue to be tried in absentia. So he posted bail and he signed this document. During arraignment, X appeared and X pleaded not guilty. During the preliminary conference, the marking of exhibits, he still appeared. During pre-trial, he still appeared. During the hearing set for the initial hearing of the case, the presentation of the first prosecution's evidence, X no longer appeared. In the next hearings, he no longer appeared. X already jumped bail. So, the defense counsel informed the court, Your Honor, I could no longer locate this accused. He is no longer in contact with me. He is no longer in this place of residence, and therefore, he went into hiding. He escaped. And so the said trial was continued in absentia. After trial on the merits, the judge convicted the said accused. And, of course, since he was not around during the promulgation of judgment, if there was no appeal, judgment became final and executory. And so the judge issued a warrant of arrest against X. The police officers armed with this warrant of arrest tried to look for X. But they could not locate X. After more than 20 years, finally, based on a tip from an informant, they were able to find the whereabouts of X, and they served the warrant of arrest, and X was placed behind bars. His counsel immediately filed a motion for habeas corpus. The said counsel said, that this client, this accused must immediately be released. Ground, the penalty has already prescribed. Has the penalty already prescribed? Must the said motion for habeas corpus be granted by the court. The court must deny the motion for habeas corpus. X can still be made to serve his sentence. The prescription of penalty has not, or the period of the penalty has not yet prescribed. Reason is, the running of the period of penalty has not yet even commenced to run. It has not yet even commenced to run because the running of the period of penalty, you start counting it from the time the offender evades the service of his sentence. And in this case, X has not evaded the service of his sentence. When he jumped bail, there was yet no sentence imposed on him. He only jumped bail during trial. When you say evasion of service of sentence, it means that he escaped the penal institution while serving his final sentence, his final judgment. So in this case, the petition for habeas corpus must be denied. X can be made to serve the penalty imposed on him. But what if X has been convicted of the crime of homicide and the judgment became final and executory? He was brought to the New Bilibid prison. He is now serving his final sentence, the final judgment. After a year of serving the sentence, he saw an opportunity to escape, and he had a successful escape from the penal institution. The prison authorities and the police looked for him. They could not locate him. Until after 25 years, they got a tip as to his whereabouts. The police officers immediately went to the place, served the warrant of arrest, and placed him behind bars. The council filed a petition for habeas corpus for the immediate release of X. If you were the judge, would you grant the petition for habeas corpus? If you were the judge, you have to grant the petition for habeas corpus. The penalty has already prescribed. It took the police officers more than 25 years before they were able to locate him. Therefore, the penalty is already prescribed. Too late. He can no longer be made to serve the final sentence imposed on him. The running of the period of prescription of penalty is interrupted or suspended when the said convict surrendered or gave himself up, when the convict is captured or arrested, when the convict goes to a country in which the Philippines has no extradition treaty, and lastly, when the convict has committed another crime before the expiration of the period of prescription of penalty. In all these instances, the running of the period of prescription of penalty is interrupted or suspended. Then the last mode for total extinguishing criminal liability is the subsequent valid marriage between the offender and the offended party. When this subsequent valid marriage between the offender and the offended party applies only to certain crimes. It will only extinguish the criminal liability of the offender in the crimes of rape, and also in the crimes of seduction, abduction, and acts of lasciviousness, in these private crimes. The moment the offender and the offended party got married, under Article 344, it will not only extinguish the criminal liability of the offender, it will also remit the penalty already imposed by the court. So even if the said offender has already been convicted and is already serving sentence, then suddenly the victim and the said offender got married. They fell in love, they got married. They opposed each other in court. And so, they got married. What is the effect? It will extinguish the criminal liability and remit even the penalty already imposed by the court. Then we have the modes for partially extinguishing criminal liability. The modes for partially extinguishing criminal liability includes conditional pardon, commutation of sentence, and good conduct allowance to be determined by the Director of Prisons during the accused's stay at the penal institution. So the first one is conditional pardon. Just like absolute pardon, conditional pardon may be granted only after conviction by final judgment. Its effect is only to partially extinguish the criminal liability of the offender because attached to the grant of pardon are strict terms and conditions. The said person granted pardon must comply with these. If he failed to comply, he becomes liable under Article 159, evasion of service of sentence. And another effect, he is not entitled to an indeterminate sentence. The other mode for partially extinguishing is commutation of sentence. Death penalty reduced to reclusion perpetua. It will because it partially extinguishes the criminal liability because instead of being subjected to a death penalty, he is now only going to serve the penalty of reclusion perpetua. Then we have good conduct allowance. This is to be determined by the Director of Prisons. Under Article 98, there is the so-called special allowance for loyalty. This special allowance for loyalty is given or credited to prisoners convicted by final judgment who escape in times of calamities and disorders, but return to the prison authorities within 48 hours following the proclamation by the Chief Executive that the calamity had already lapsed. So if they return within 48 hours, there will be 1/5 deduction, 1/5 credit based on the term of their sentence. If the said convict, however, did not leave the penal institution and stayed put, and he survived the calamity, there will be 2/5 deduction based on the term of his sentence. So there was an earthquake. X was among the prisoners who left the penal institution. When he heard the president declaring that the calamity, the earthquake had already lapsed, within 48 hours, X returned to the prison authorities. What is the effect on his criminal liability? There will be 1/5 deduction based on the term of his sentence. But what if despite the earthquake, despite the fact that other prisoners left the penal institution, X just stayed put inside and hid under a table? He survived the calamity. What is the effect on his criminal liability? There will be 2/5 deduction based on the term of his sentence. But what if X is a mere detention prisoner? He is not yet a prisoner convicted by final judgment. He is merely a prisoner, a mere detention prisoner serving preventive imprisonment because he happens to be a poor person who has no money to post bail. So there he was, while the case is ongoing trial, he is behind bars at the city jail. So let's say X was charged with a crime of homicide. It is bailable, but he doesn't have the money to post bail. So while the case was ongoing trial, there he was at the city jail. He was confined there. There was an earthquake, and the said prisoners, the said detention prisoners left the penal institution during the said earthquake. 2 days thereafter, X heard the president saying the earthquake had already lapsed. X immediately returned to the prison authorities at the city jail and gave himself up. What is the effect on his criminal liability? Under RA 10592, amending Article 98, it is provided that this benefit of credit on the penalty shall apply not only to prisoners convicted by final judgment, but also to mere detention prisoners. So in this case, the 1/5 credit on his, based on the term of the sentence, shall also be applied to X, a detention prisoner, that is, in case he is convicted. So in case he is convicted, there is 1/5 deduction based on the term of his sentence. What if X, a detention prisoner, did not leave the penal institution? He just hid under the table. There he was. After the earthquake, he survived. What is the effect on his criminal liability? There will be 2/5 deduction on the term, based on the term of the sentence in case he is convicted. Because under the amendatory law, this special allowance for loyalty applies not only to prisoners convicted by final judgment, but also to mere detention prisoners who are under preventive imprisonment. Under Article 100, every person criminally liable is also civilly liable. So for every criminal action filed in court, the civil action goes with it. For every criminal action filed in court, the civil action goes with it. That is the general rule. There are exceptions to the rule. In the following cases, in the following instances, the filing of the criminal action does not carry with it the civil action. First, when the offended party waives the right to file a civil action. Second, when the offended party reserves the right to file a civil action, which reservation must be made before the presentation of the evidence for the prosecution. And lastly, when the said civil action was instituted ahead of the criminal action. In these three instances, the filing of the criminal action does not carry with it the civil action. So, for every criminal action filed in court, the civil action goes with it. So what if the said accused was acquitted in the criminal action? Does it necessarily follow that the private complainant can no longer recover from the civil action? It depends on the kind of conviction. In the following instances, acquittal in the criminal action totally bars recovery in the civil action. First, when the judgment of acquittal states that the accused is not the author of the crime, or the accused did not commit the act or omission alleged in the information. Or when the judgment of conviction states that the accused is not guilty of either criminal nor civil negligence. In these two instances, an acquittal in the criminal action totally bars recovery in the civil action. On the other hand, in the following instances, acquittal in the criminal action does not bar recovery in the civil action. First, when the judgment of acquittal is based on reasonable doubt. Second, when in the judgment of acquittal, the court states that his liability is not criminal, but civil in nature. This happens in estafa cases based on contracts. And third, when the judgment of conviction states that the civil liability of the accused arises from other sources of obligation. In these three instances, acquittal in the criminal action does not bar recovery in the civil action. The 6-year-old boy suffered stomach pain, and so the 6-year-old boy was brought to the hospital by his parents. And after diagnosis of the doctor said that an appendectomy operation must be done on the boy. And the doctor also suggested that a circumcision operation be also performed on the boy. And the mother, the parents agreed. So the said appendectomy and circumcision operation were done on the boy by the said doctor. After that, when they went home, the mother noticed that her boy has a weird way of urinating. The penis of the boy was swollen. The testicles have blisters. And so, she went back to the said doctor who performed the operation. What happened to my boy? And the doctor said that is normal. And the doctor only gave the mother antibiotics for the boy. But months passed. The boy did not recover. The condition even became severe. And so the mother went to another doctor. And after examination, the doctor said that this young boy suffered a damaged urethra, which can no longer be repaired. And so because of that, the mother filed against the doctor who performed the operation a case of reckless imprudence resulting in serious physical injuries. After trial on the merits, the judge acquitted the doctor. The judge said, the private complainant, that is the prosecution, failed to prove the negligence on the part of the said doctor in the performance of the said operation. And so it was an acquittal. And even if there was an acquittal, the judge, however, imposed civil indemnity against the said doctor. And so the doctor now questions this grant or award of civil indemnity against him. And so he went to the Supreme Court. The argument was that since he was acquitted of the crime charge, therefore, there should be no civil liability imposed on him. Supreme Court said, there are two kinds of acquittal. First, an acquittal based on the ground that the accused is not the author of the crime. If the acquittal is based on the ground that the accused is not the author of the crime, totally, there can be no award of civil indemnity. But the other kind of acquittal is an acquittal based on reasonable doubt. If the acquittal is based on reasonable doubt, there is award of civil indemnity. If it can be proven by convincing evidence that indeed the said victim had been damaged. And here, based on the ruling of the court, it is evident that the young boy had been damaged. Hence, Supreme Court said, since the acquittal of the said doctor is based on reasonable doubt, the prosecution failing to prove his negligence in the conduct of the operation, then the award of civil indemnity is proper. But what if X was charged with reckless imprudence resulting in homicide? The information filed before the court state that X, driving his car recklessly and hit and bumped the victim. The victim died, and so X was charged with reckless imprudence resulting in homicide. After trial on the merits, the judge acquitted the accused. In the acquittal, the judge stated, no one among the witnesses presented by the prosecution was able to pinpoint to the accused as the driver of the vehicle that hit and killed the victim. So the judge acquitted the accused, but the judge imposed upon him civil liability. And so the accused went to the appellate court questioning the said civil liability. Is the grant of civil liability correct? According to the Supreme Court, here, the judgment of acquittal is based on the ground that the accused is not the author of the crime. According to the decision of the court, no one of the witnesses presented by the prosecution was able to identify the accused as the one driving the vehicle that killed the victim. Therefore, in effect, he is not the author of the act or omission alleged in the information. He is not the author of the crime, hence, the award of civil indemnity has no leg to stand on. There should be no award of civil indemnity. What if the crime was committed by an insane person? The crime was committed by an imbecile person. The crime was committed by a minor, 15 years of age or under. Under Article Article 12 exempting circumstances, they are exempted from criminal liability but not from civil liability because a crime has indeed been committed. Who shall answer for the civil liability? The person who has control and custody of the insane, the imbecile, and the minor shall answer for the civil liability, except when they are able to prove that there was no neglect or negligence on their part. If they were able to prove that there was no negligence on their part, then it is the properties of the said insane, imbecile, or minor that shall answer for the said civil indemnity. If the accused has been charged with a crime, and it was proven that he committed a crime based on the compulsion of an irresistible force, based on the impulse of an uncontrollable fear of equal or greater injury, he is exempted from criminal liability. These are exempting circumstances under Article 12, but not from civil liability. Who shall answer for the civil liability? Primarily, it is the person who employed the fear, the person who employed the threat, the irresistible force. If he happens to be insolvent, then the accused himself shall answer for the said civil liability. For crimes committed by pupils and students, the teachers and the schools are subsidiarily civilly liable. For crimes committed by their children, the parents are subsidiarily civilly liable. For crimes committed in their establishment, the innkeeper, the tavern keeper, and the proprietor of the establishment are subsidiarily civilly liable. So what if X checked in a hotel? X had valuables with him. And so X informed the person at the front desk of the said hotel that she had valuables with him. And so the said front desk officer gave to him the rules and regulations of the said hotel as to the care and vigilance of valuables. And X complied with the said rules and regulations of the said hotel. He deposited all his valuables at the said front desk officer. However, that night a robbery took place, and among the things taken in the said hotel were those valuables of X. Later, the robber was arrested and he was prosecuted for robbery. After trial on the merits, he was convicted. Penalty was imposed, imprisonment. There was also civil indemnity. He was being asked to return the said jewelries or the value thereof. However, judgment became final and executory. However, the said convict is insolvent. Who shall pay for the said civil indemnity? The owner of the said establishment is subsidiarily civilly liable. Therefore, he shall be the one to answer for the said civil indemnity. But what if in the course of the said robbery, there was an exchange of gunfire between the robber X, between the robber, as well as that of the security guard? And in the course of the said exchange of gunfires, the said robber was able to shoot the said security guard who died. The robber was arrested. He was prosecuted for the crime of robbery with homicide, and thereafter he was convicted by final judgment, and he was imposed with civil indemnity. But he was found to be insolvent to pay the civil indemnity. Is the owner of the establishment subsidiarily civilly liable? The owner of the establishment is not subsidiarily civilly liable. The owner of the establishment shall not be subsidiarily civilly liable if the crime committed is any crime involving robbery with violence against or intimidation of persons. Here, the crime committed is robbery with homicide, a form of robbery with violence against or intimidation of persons. Therefore, the said innkeeper, tavern keeper, or proprietor of the establishment is not subsidiarily civilly liable except when the offender himself is an employee of the said establishment. But what if there was this establishment in the province, based on the ordinance issued by the Sanggunian, this business establishment may operate only on weekdays. Monday to Friday, they cannot operate on Saturdays and Sundays. But that Saturday, there were many clients, and so the business opened. A crime was committed inside the said establishment. The offender was charged, he was found guilty, imposed with civil indemnity. He cannot pay the said civil indemnity, he was insolvent. Is the owner of the establishment subsidiarily civilly liable? The owner of the establishment is subsidiarily civilly liable whatever be the crime committed, because the establishment was in operation in violation of the law, in violation of the ordinance, in violation of the special rules and regulation of the police. So for whatever crime be committed, the said owner of the establishment shall be subsidiarily civilly liable. For crimes committed by employees in the performance of their functions, the employer shall be subsidiarily civilly liable if the following are present or proven in court. First, that there exists an employer-employee relationship, that the employer is engaged in some kind of industry, that the employee committed the crime in the performance of his duties, and lastly, that the said employee has been convicted by final judgment. The writ of execution was issued, but it was returned unsatisfied as he was insolvent. The employer is now subsidiarily civilly liable. X was charged with a crime of reckless imprudence causing damage to property. He hit a car while in the performance of his duty as the driver of the company. After trial on the merits, he was convicted. He was imposed with a penalty of fine, plus also civil indemnity. He must answer for the damages on the said car. The judgment became final and executory. The writ of execution, however, was returned unsatisfied. He was insolvent. So how can the owner of the car recover the civil indemnity, the value of the damage on the car? Must he file a separate civil action in order to recover damages? The owner need not file a separate civil action. In the very same criminal action for reckless imprudence causing damage to property, all that he has to do is to file a motion for the issuance of a subsidiary writ of execution, this time against the employer. And according to the Supreme Court, this motion for the issuance of a subsidiary writ of execution is a litigated motion, therefore a copy must be given to the employer. And the said employer, in the name of due process, must be given his day in court. It is during this time that the requisites I stated must be proven. The moment it is proven, there is an employer-employee relationship, the employer is engaged in an industry, and then thereafter the crime was committed while in the performance of his function, if these are proven, the liability of the said employer is absolute. Therefore, he shall be answerable for the said civil liability subsidiary. And what are the civil liability? The civil liability includes restitution, reparation of damage caused, indemnification of consequential damages. Restitution refers to the return of the very thing taken, even if the thing taken is already in possession of an innocent purchaser in good faith. It can still be returned to the proper owner, except when the innocent purchaser in good faith bought it in a public fair. If restitution is no longer possible, we have the so-called reparation of damage costs. The court shall determine the value of the said thing taken. The court shall take into consideration its special sentimental value to the owner thereof. And then we have indemnification of consequential damages. In indemnification of consequential damages, we have moral damages, we have exemplary damages, and we have also actual damages. All of this can be imposed by the court against the said convict if it is proven during trial. So this is more on civil law. In a recent case, however, the Supreme Court said that insofar as heinous crimes are concerned, I think it is People versus Cebu. If it's either 2018 or 2017, I will exactly state it to you tomorrow. The Supreme Court made a summary as to civil liability in cases of heinous crimes. Supreme Court said, if heinous crimes are committed, murder, rape, if heinous crimes are committed, if it is in the consummated stage, the civil liability will be 100,000 pesos. Moral damages, 100,000 pesos. Exemplary damages, 100,000 pesos. If it is in the frustrated stage, civil liability is 75,000 pesos. Moral damages, 75,000 pesos. Exemplary damages, 75,000 pesos. If it is in the attempted stage, civil liability is 50,000 pesos. Moral damages is 50,000 pesos. And exemplary damages is 50,000 pesos. That is the summary of the Supreme Court as to the award of civil liability in cases of heinous crimes. So those are the civil liability which may be imposed on the said person who has been convicted. So that finished Book 1. Do you want me to continue with Book 2? No? Okay. So I'll start with Book 2 tomorrow.